This is the Deseret News National Edition, when your family needs to know more.
Hi there, and welcome to the Deseret News National Edition. I'm Mike Hedrick. Good to see you today. A legal battle over the Affordable Care Act's contraception mandate went before the U.S. Supreme Court on Tuesday to determine whether a for-profit corporation has the same conscious rights as its individual owners do. Well, legal experts say the ruling will have implications not just for President Obama's embattled health care reform law, but also for the free exercise of religion in commerce.
Women must decide.
It is one of the most controversial,
oh Lord, we pray,
closely watched arguments of the Supreme Court, a challenge to Obamacare by privately owned for-profit businesses based on religious freedom.
We believe that Americans don't lose their religious freedom when they open a family business.
Lawyers for the Hobby Lobby chain of arts and craft stores owned by evangelical Christians and Conestoga Wood Specialties, owned by a Mennonite family, told justices that requiring companies to provide certain types of contraceptives violates the owner's Christian faith.
We never thought we'd see a day when the government would tell our family we could no longer run our business in a way that affirmed the sanctity of human life.
But the court's liberal justices seem to defend the so-called contraception mandate. Justice Elena Kagan saying if the court grants the exemption that, quote, you would see religious objectors coming out of the woodwork to challenge everything from Social Security to immunizations.
Women have the right to make their own decisions about their health care and their birth control, and it's not their boss's decision.
Solicitor General Donald Verrilli argued freedom of religion applies to citizens and not corporations. He faced strong questions from the conservative wing of the court, Justice Samuel Alito referring to the First Amendment that ensures religious freedom when he asked what is it about a for-profit corporation that is inconsistent with the Free Exercise Clause.
The people united!
Both sides in this debate will continue to exercise their freedom of speech, waiting on a ruling expected in late June. And an indication of how far-reaching the High Court's ruling will be is the number of lawsuits the ACA's contraception mandate has actually generated. The Hobby Lobby and Conestoga cases are just two of 47 lawsuits against the government brought by for-profit companies. Another 47 nonprofit groups, including religious-affiliated schools and charities, have also sued, making similar claims here, according to the Beckett Fund for Religious Liberty. That's a Washington, D.C.-based law firm representing Hobby Lobby and several other those nonprofit groups. Now, joining me right now to discuss these cases here, Paul Edwards, editor of the Deseret News, and reporter Mark Kellner, who has been following the Supreme Court case in Washington. And good to see both of you gentlemen today. We appreciate you taking the time. Let me start off and asking a couple questions here. Both Hobby Lobby and Conestoga, they claim the government's birth control mandate violated the 1993 Religious Freedom Restoration Act. In this first one, Mark, I'm going to ask you, how did this case actually end up in the Supreme Court?
Well, this case ended up in the Supreme Court because lower courts disagreed on whether these corporations deserve or don't deserve that exemption. In the case of Hobby Lobby, it was granted, in the case, if memory serves me correctly, by a lower court, and in the case of Conestoga, it was not granted. So in each case, the other side appealed. The government appealed the Hobby Lobby ruling, and the plaintiffs, Conestoga, appealed their ruling.
All right. Well, Paul, let me ask you this then. Could this case influence state cases involving small business owners who refuse to serve same-sex nuptials for religious reasons? And we've kind of seen this in the past in Arizona.
Well, this was actually one of the major arguments from the government itself, was that there would be a parade of horribles if you granted these for-profit businesses the opportunity to express their religious rights and protect them in this way. As it turns out, I mean, your specific question, Mike, about how this would affect state cases, the Religious Freedom Restoration Act applies specifically to actions of the federal government. So this act passed in 1993 initially applied to all governmental action in the United States, but it, in an important case litigated early on, the Supreme Court said that this act didn't apply to state governments. So how this plays out in other cases going forward, I think, is an open question in the sense that it really sets up a judicial test that's being balanced here. And this is one of the first major cases where that test of the Religious Freedom Restoration Act is being interpreted by the courts and by the Supreme Court. And as they're wrestling with this, you see them, the justices, really concerned about how this will play out going forward.
Okay, now while this case will ultimately be decided by the Supreme Court here, Hobby Lobby has taken a unique approach to reach out to the public, and they've done so through social media. Mark, do you believe that this has actually helped their case?
Well, it's helped explain their case to their constituents, namely their customers and the public. I doubt seriously that the justices themselves will be relying on tweets or Facebook postings in the making of their decision. But they want to explain themselves as what they view themselves to be: good, faith-based employers who treat their workers properly. They pay them a wage 80% higher, at least, than the minimum wage. The Hobby Lobby stores are closed on Sundays. They do provide good health benefits, they say. They just object to these means of contraception, which they believe can induce an abortion.
So what you're saying is if we give one of these justices a Facebook poke, it probably will have no effect whatsoever.
I would be astonished if any of the justices...
That is a great, very good point. All right, now, analysts agree Justice Anthony Kennedy may once again be the swing vote that decides this case here. Paul, any guess on the legal dilemmas that he could be facing right now?
Well, there are kind of three different parts of how this act is interpreted. And a lot of people thought that going into this, it would be determined on what they called the threshold question about whether or not a for-profit entity counts as a quote-unquote person under the Religious Freedom Restoration Act. My read of the argument that happened before the court is that that really wasn't where the argument went. The justices were very interested in the substantive question about whether or not there was a burden of religious exercise and how this would play out in what is called a balancing against the least restrictive means test. Now, all eyes are on Kennedy in some ways. I was actually fascinated by Justice Breyer's questioning in the case. I think he showed a level of interest and engagement that suggests that of what is usually seen as the liberal wing of the court, that Justice Breyer may be really questioning the proper way to interpret this statute going forward. So we'll have to wait until the end of June to see how they come out. That's likely when we would see a decision on this.
That's what we understand. All right, last thing here. How important will this case be in the fight for religious freedom? And I'll start with you, Mark.
Well, in terms of other cases before the court, including that of the Little Sisters of the Poor, a Catholic order of nuns who are engaged in social services and are challenging the mandate from the nonprofit perspective. They are what I guess you could call a para-church organization because they're not a religious body such as a church or a parish that holds services. The government says the Little Sisters have to provide these methods of birth control, and the Little Sisters say we object to birth control, period, as part of our religion. So whatever happens in Hobby Lobby could influence the Little Sisters, and it could also play into state laws about discrimination and religious rights in much the same way that Justice Scalia's comments about the Defense of Marriage Act, even though he was in the dissent, have been cited by a number of federal judges in overturning state laws that are banning same-sex marriage.
Paul, you got about 20 seconds. What can you tell me?
Hugely important case for religious freedom. The Religious Freedom Restoration Act was an attempt by Congress to pre-commit to a robust protection of religious freedom in a variety of circumstances that couldn't be anticipated. It provides a judicial process for doing that. Whether the Supreme Court upholds what Congress intended will hang in the balance.
All right. Paul Edwards, Mark Kellner, both of you, thank you very much. We appreciate your time and your input here.
Thank you, Mike.
All right. When we come back, it is tax time, and more people are filing online, but is that the best way to do it? We're going to get some advice from our MoneyWise guru coming up next.